off with the Q&A, if you can maybe elaborate on the term Sharia, and then in various dimensions we've seen it across history, and especially the time frame you mentioned, and maybe even how that compares to modern use of it.
So the literal meaning of Sharia means path to a watering hole. And the way I like to understand it and describe it to people, because it helps me, is that Sharia is what God wants us to be, what God wants law to be, what the manifestation, the true manifestation of Islam should be, right? So I like to think of Sharia as sort of, up on top. It's the greatest thing we could possibly achieve. Versus my comparison is usually is to fiqh, which is the human interpretation of the Sharia. So I like to think of the Sharia up here, and inshallah, like one day, we're always trying to get closer to it, versus scholars being here, always trying to build ladders to get to the Sharia through different processes of interpretation, right? So fiqh being the human interpretation, and that's really what connects the vast differences of opinion, because when we've got different methodologies, different scholars trying to build their way up to the Sharia, you've got different pieces of evidence and different ways of getting there. But Sharia is perfect and complete in every sense. And unfortunately, oftentimes we associate human fallibility, human errors to the Sharia, when that is entirely impossible, because the Sharia is God's law and is entirely perfect. Do you want to answer from here?
Yeah, audience question, please, go ahead.
Can I ask a question?
Go ahead.
Okay, perfect. So with regards to codification, I think obviously you know what you're talking about. But in the West, for example, the whole idea of codification is centered around the idea of having consistency, predictability, and transparency in the law. So the idea is, I as a layperson, or even a legal counsel who wants to obviously represent me in court, can go to a certain place and be certain that there's a basis upon which my legal rights and obligations will be determined. Mm-hmm. And even when things are not codified, there's a system of precedent. I'm sure you're familiar with the idea of stare decisis. Mm-hmm. So courts are bound by the way they ruled in the past, essentially like the Western form of taqleed, if that makes sense. And the idea is that people should have an idea before they go into court, how are my rights and obligations, legal rights and obligations, going to be decided? And the idea that I can go into courtroom A and have the judge decide one way, and then my neighbor goes to courtroom B and has his case decided a different way, even though the facts are identical, that's a pretty big problem, because obviously the law is no longer predictable. It's pretty arbitrary based on which court I go to. Mm-hmm. It's no longer consistent, and citizens will have a hard time organizing and arranging their legal affairs. And this whole idea is not unique to the West. There are Muslim scholars who did call for codification. You might be familiar with Ibn al-Muqaffa and the fact that he was really annoyed that you have one qadi in a jurisdiction judging a certain way, and then another qadi judging in a certain way, and things were just in chaos. Mm-hmm. And we also have the principle in Islamic law that رأي ولي الأمر يرفع الخلاف. So if the wali al-amr, historically known as the Khalif or the Sultan, decides that we're just going to take the Hanafi opinion on this thing, this is the law across the land, despite there being other opinions, but we just can't have citizens arbitrarily having their legal rights and obligations determined depending on the method of the person they ask. And so I think, and I want to get your thoughts on this, that the problem really isn't codification. In my humble opinion, codification and predictability and consistency is the law. In the law would actually help us as Muslims, present the Sharia in a positive light in Muslim countries. I think the problem is a lack of codification, a lack of consistency. If ahkam and fiqhi opinions are codified, that doesn't mean our ulama are no longer relevant, mm-hmm. or that the flexibility is gone. In the same way, in the West, for example, we have codification, we have a system of precedent, but we still have legal experts who develop new opinions, novel opinions, unique conclusions, and they pressure government to adopt or reformulate their opinions. You also have legal flexibility in the sense that you on the Supreme Court, for example. So I'm Canadian. I don't know. I think you have more than one judge on the Supreme Court in the U.S. So you have a majority opinion and you have a dissent, and the dissent might one day become the law. So it's not like you have just one law and that's it, and things are no longer flexible. There is this balance between having flexibility and dynamism in the law, but also there has to be consistency and predictability. And this idea, I think that the beauty of Islamic law was that it was so colorful and had many different, it was very flexible. It is a blessing in a certain way, but I think a state has to run in a certain way and there has to be predictability. So it could be a curse at the same time. And I think one of the curses that Muslims are suffering from is a lack of codification in Muslim law.
Jazakallah khairan. Yeah, no, I think that's a very important clarification. And that was something that most Muslim scholars really appreciate about the process of codification. And I think that in terms of the clarification, I think it's important that I refer to as the consistency in that process, right? So when you have codification of you know, a lot of the criminal penal laws or a lot of the economic laws that were, particularly this comes up in discussions when Europeans were in the Ottoman Empire or in the Muslim Empire, they needed consistency in that regard. And that was something that a lot of the Muslims had appreciated themselves. But the problem with, when it came to particularly family law, and again, this might be in other areas as well, but my particular focus in my own studies is family law, is that it was extremely inconsistent in how it was applied. So in some situations, it was suddenly there when it came to, you know, divorce, but when it came for marriage or a woman receiving her rights post-divorce, then suddenly she was just referred to a mufti or someone else that was haphazardly trying to clean up the situation. So it wasn't entirely codified. You have sections that were codified, and it's fascinating. Dr. Tucker has an article about how personal status law was codified in that Ottoman Family Law Code of 1917, and how literally just you know, the entire Hanafi text that was used to codify wasn't even done so completely. And so you've got some answers to others, and then you've got end up having inconsistency in the rest. And so I think that the point of consistency is a good point of clarification.
And going along the same lines, especially, you know, regarding penal code and whether there's flexibility or not, if you can comment a little bit on modernization of penal code and whether you see that to be, whether there's a role for that, how we can, you know, think through the way it's changed across history, and how it can potentially be applied in our modern day. The question that came to you was actually talking about how that's the negative portion of Sharia in people's perception. Mm-hmm. So if you can comment on that.
So, a scholar, I mean, I can't talk much on contemporary American law, all of that stuff. I will hold back on talking about that just because that is not my area whatsoever. But a scholar a couple years ago actually had called for a moratorium on hudud that's being implemented overseas, because what was happening was that you've got just the poor were basically people who were poor were having their hands chopped off, and the people who had connections or wasiyah or whatever wasta to high officials got away with everything, right? Whether it was any form of, you know, something that would qualify as a penal violation. And so that was the problem. Again, it goes back to that form of consistency. So depending on your status in society and your connections to the world, that wasn't being applied appropriately. And so I would fully agree in that sense, in that there obviously needs to be a reform in that regard because of that inconsistency. But unfortunately, I cannot speak to the best advice for that because that is not my focus.
So you mentioned the loss of ulama and how that was a turning point within the trajectory of Sharia within Islamic societies in that context. Can you talk a little bit about the impact of that loss? What were, you know, the differences between the societies that had that and that didn't, and how that positively or negatively impacted the community?
Yeah, so just to elaborate a little more, because I didn't have a chance to talk about it, one of the most notorious things that scholars were there in terms of regulating that balance and serving as a judicial check on rulers was that they created mirrors for princes. And what that is that it's a form of literature where scholars would create basically books of advice for the rulers. And essentially that was a form of authorizing that ruler or caliph. And so what happens is that if there's no prominent scholars that are verifying that caliph's rule, then the people are not going to be very supportive of a particular scholar. So I know that's a little confusing, so let me give you an example. If an Umayyad caliph, for example, comes into power a little haphazardly and wants to clean up that mess or wants to get the community's communities on his side, what he would do is that you would go to certain qudal, you go to certain scholars, and have them write on your behalf, have them issue different books on your behalf to sort of verify that. And so scholars obviously pick and choose. You've got scholars throughout history serving time in jail for refusing to do so, and then you have scholars who, for rulers that were acting justly or in some form of accordance with the Sharia, would verify them, and that would sort of create that peace throughout between communities, the community on the ground and the rule at large. And so when the scholarship goes away, yes, you still have scholars acting today, but again, it's not the same form. What you have is the rise of intellectuals as well in the early 20th century who are being trained in Western academies. They're being trained differently through different processes. They're doing, Western law on top of Islamic law, and they're never really perfecting what they're doing. And so Rudolf Peters has an article about this, essentially the incompleteness of their education, and then what the intellectual class decides is, basically what they are speaking on behalf with authority of the Sharia when they might not necessarily have that full knowledge of it. And so there's this miscommunication between the two groups, and the ulama class that did exist is now being replaced by this intellectual class, which are not the same type of scholarship that we would have seen a few centuries ago. Again, there's a lot of discussion in terms of reform, in terms of the impacts of modernity, and not to say that intellectuals are necessarily a negative thing. It's just that, again, that type of those forms of inconsistency and miscommunication between the two.
And given those inconsistencies and the differences over time, especially after that turning point, do you find it to be necessary to capture the multifaceted nature and characteristics of Sharia in determining any kind of ruling from it or in codifying it broadly?
Sorry, can you clarify?
Yeah. So essentially, so do you find it necessary or even possible to capture the multifaceted nature of Sharia when determining rulings and when examining the codification of it as a legal code?
In contemporary law?
In the modern state.
Yeah. I have no problem saying I can't answer a question, and I'll defer to that. Inshallah, when Sheikh Umar is here later, Dr. Nazir, Zuhair, if they can answer modern questions, contemporary, I don't think it's a good idea for me to answer.
Right, and maybe even from precedents in history. Did you see it as a necessary component to recognize that multifaceted nature of the Sharia in the different civilizations that it was applied to, as opposed to having a narrow codified version? I think we touched on this earlier, but maybe if you have any other thoughts.
Yeah, no, absolutely. And I think what's really cool is under the Mamluk Empire, Dr. Muhammad Fadl has a paper on this, is about how the caliph, instead of having one madhab throughout the empire, he actually allowed for the four qudal, the four judges. So every madhab had its own court, had its own legal system, and so people had that flexibility in that in being able to go and get consistent answers, but from different madhahib. So that was prevalent as well.
And our second to last question, inshallah, is regarding fiqh books and the codification of fiqh. Do you view that to be positive or negative in your opinion? And what thoughts do you have about it?
So the codification of fiqh books is exactly what was happening. Again, the Sharia is not something that's ever going to be in a book. When we're talking about Islamic law, we're usually referring to fiqh that's aspiring to maintain the values of the Sharia. And so, again, there is definitely benefits to it, but in terms of the way it was applied was very inconsistent and had negative consequences on the Muslim community. And again, it's not simply the codification. It was codified, and then it was every other line was also embedded with Western legal rulings. So there was sort of this awful mesh. Now, if that was properly, the codification was complete in at least one form or another, then there definitely would be conveniences to that. But unfortunately, there hasn't been much on that.
Please go ahead.
I guess my question is a follow-up on this one, because I was asking about what your thoughts on, you talked about qualification as a result of a political origin or like imposed by governors or things like that, or started as an involvement of the state. But what about the fiqh process itself? Like, do you think it's a form of codification that also kind of produced Islamic legislation? Earlier, before the Ottoman Empire, it was like the madhahib itself, like Malik or Shafi'i, were basically researchers looking at Islamic law, but then their thoughts, written in books, started being taken as like a certain code that needs to be followed, and instead of people have like, when you look at the hadith or ayah itself, you get a lot of bigger exposure. You can be applied differently, but now people read the fiqh book or a certain madhab and sort of codification as well. I mean, does that same effect?
Yeah, that's a great question. So essentially, when scholars were trying to create fiqh books or legal opinions, they were codifying the Sharia. But the difference is that when most scholars were writing their fiqh books, it's very hard to find a scholar that says this is, the first and last answer. Shafi'i himself famously says that if you find an answer that has better evidence than mine, then follow that person's opinion, right? So they're sort of offering their own methodology, their own opinions to an answer, but not necessarily deeming them as the only answer. And so that's really the biggest setback to the codification process, particularly when it comes to Islamic law, because it reduced the number of options. Versus fiqh, you've got the mashhur opinion, you've got the process of tarjih, of preponderance, choosing which opinion based off evidence, and there's so much, so much variance in that, and beauty in that, that it would differ from that process of codification that I'm talking about. Jazakallah khair, was a good question.
So Jazakallah khair, Sister Tesneem. With that, we'll conclude this segment of the conference. Inshallah.